The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty from O'Flaherty Law. I hope you find this Learn About Law video and podcast helpful. If you need some help, please feel free to give me a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in this video, we answer the question, can a child be forced to testify in court? The overarching goal of the Illinois Marriage and Dissolution Act and the Juvenile Court Act in regards to children is the protection of the child's best interest before the courts. According to the Juvenile Court Act, a child cannot be forced to testify, and any refusal by the child to testify cannot be met with legal action, even if opposition from one or more legal age parties exists. For example, an Illinois court can rule that a father's due process rights were not violated when refusing the father's attempts to compel a child to testify. There are ways that the court can obtain the information needed without court testimony from the child, but certain scenarios necessitate that testimony. The Illinois Marriage and Marriage Dissolution Act allows the child to be interviewed by the judge outside the courtroom, provided the four guidelines for the interview are met. 1. The judge only interviews the child, not the parties involved, and the involved parties will not be present. 2. The interview must take place in the judge's office. 3. In order to ensure a fair interview, the attorneys for both parties must be present. And 4. A court reporter must be present to record the entire interview so that the recording of the judge's interview can be used at the custody trial. The bar for what the judge can use in her ruling differs depending on what hearing is taking place. At the adjudication hearing, if no other evidence is brought forward, the child's original statement will not be enough to sustain a finding of abuse or neglect, but if a pediatrician and/or another physician find evidence that corroborates the child's statement, the finding will typically stand. Furthermore, in the case of sexual abuse, the court may also accept that a child's age and appropriate detailed knowledge of sexual matters and evidence of the child's age and appropriate sexual behavior corroborate his or her out-of-courtroom statement. While a case may require in-court testimony from the child in order to sustain findings of abuse or neglect, it may not be in the best interest of the child to subject herself to direct and cross-examination. This is not a black and white decision and often falls to the guardian ad litem, GAL, to make that determination. If it is determined that it is not in the child's best interest to testify in court, evidence supporting that decision, preferably from a medical professional, should be presented along with the other relevant arguments. Alternatives in this situation include hearsay testimony in post-adjudicatory proceedings and testimony from other witnesses as to what the child may say if asked the same question. As always, thank you for tuning in.
Hi, this is Kevin O'Flaherty again from O'Flaherty Law. Just want to let you know we offer free consultations in many areas of law, and we have several geographic locations for your convenience. So if you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. And thank you again for watching and listening.